Diane Weinberg and Richard Morgan of Morgan and DeSalvo, and we are here today because we had a really interesting discussion just a few minutes ago about a seminar that was given this morning by the Estate Planning and Probate section of the Atlanta Bar Association. And the speakers at this meeting were attorney Brian Deutsch and mediator and dispute resolver Rebecca Zimmerman. And I wanted to talk to Richard a little bit because, Richard, I know you have training as a collaborative attorney. What does that involve?
There is another alternative dispute resolution process other than mediation and arbitration. It's called collaborative dispute resolution. And the theory is that both parties to a dispute have their own lawyer, but they act in a collaborative manner. All the facts are on the table, so they get if they need a business appraiser, they use the same appraiser. If they need a CPA to crunch numbers, they get the same CPA to crunch numbers for all the parties. And they have a third party in the middle who's more of a social worker type of person who will help the parties kind of keep moving down the path of resolution. And the entire process, and the lawyers work together trying to resolve it on a win-win basis. And the whole process is based on the fact that almost a mass majority of cases will eventually settle. And since they're eventually going to settle, let's just go ahead and plan we're going to settle. And if the parties can't end up settling it, everyone leaves, get their all new lawyers, and start from scratch and go fighting the court process. Okay,
now one of the interesting parts of this morning's conversation, I understand there was a discussion as to whether legal standards should be included in any kind of dispute resolution. What are your thoughts about that? There were some people who suggested that a successful mediation doesn't actually look at what the underlying law is. You simply consider what would make the parties come to an agreement. What are your thoughts?
I have a very strong opinion. So I think the issue becomes one of power in the negotiations because it's a negotiation, it's a voluntary act.
Always. There could be
a court could force you, but you do not have to actually settle. Right. So it is a negotiation. If you're actually going to settle, it is a voluntary settlement. You may be forced to sit down, but you're not forced to settle. The party with the most power that believes that if they go to court, they will win. So not necessarily the most power. The party believes they're right, not because they're delusional, but because they actually believe they're right. Their lawyer believes they're right based on the facts. That party, by going to mediation, is really trying to settle, and they would like what a court would do to matter. Because if they could go to court and let's say we're fighting over $100,000 and the court says, yes, you get $100,000, the other person would get zero, they would like that to be part of the mediation so that the other person doesn't get 50-50. So it would affect the negotiation. The party without the strongest legal position, their job is to get a better result than they would get in court potentially. So I believe you should consider what the court would do. The other doesn't. The reality is the parties can always walk away. What happens though, and this is where I get kind of tight about all this stuff. What happens though, if you have a bad actor as the other side, so your side, you believe if you go to court, you will win. Except for the judge doing what they feel like it, if you believe they actually apply the law in the proper way, you're going to win. If there is a bad actor on the other side, your client may believe that they cannot stand them, they want out, and they will actually pay for them to go away. And this process allows the bad actor an easier way to settle and get more than they actually deserve. So that's my take on it.
Yeah, and I want to follow up with that because I see this a lot in guardianship disputes and conservatorship disputes where you have a family that's very, very deeply divided. And sometimes the court, and I have this in one case, the court has ordered us to mediation. And in this case, this family, there was a divorce. It was a very ugly divorce. And they had to do mediation as part of the divorce process. So when I saw this mediation order coming from the court, of course I'm going to go in good faith with the idea of settling. But my first thought was, well, it really didn't work in the divorce family law context. I don't think we're going to get a better outcome here simply because we're now in probate court talking about a guardianship dispute. I just don't see the families, the people coming together. If they couldn't work well before together, they're not going to work well together now. Really, I think in the guardianship context, we'll have it, and I've seen this is typically when it comes to my desk, we've got one person who's taking care of mom or dad or who the disabled child is, but typically it's a parent. And they're not allowing other siblings access to this, or other family members access to this person. They're a bad actor in their acts. And it's not just because they feel like the other person can't take care of them. There really is an underlying sibling issue that they felt like the other child got more love, their sibling got more love as a child, and now they're not only controlling mom, but they're sticking it to their sibling.
Now, there could be the opposite,
yes,
where one of the kids is a good kid, and they're protecting them from a bad actor child.
Sadly, I don't have that issue really. I haven't encountered that as much in mediation. And again, I'm really not a big fan of mediation in these contexts, because whatever the context is, when somebody walks into my door and says there's a fight and there's a dispute, unfortunately the reality is, if they could get along, if they could settle the case without me, they would have. All right, but they're not going to. So we already know that there's a certain amount. People have already done a certain amount of digging in. They've drawn those lines, and they're not crossing them.
Right. And I can also say, I know that some lawyers' position is their goal, if they represent the person without the good case, their goal is to have a case good enough to get by summary judgment, which means there has to be a fact question that would determine the case. If there's a fact question, you get through summary judgment, so you actually have to go to trial to determine the facts. And in those situations, the lawyer's position is really, or their strategy, is just to get to mediation so they can settle, so they actually get something for their client that would likely lose when they go to court.
Yeah, it can. And in the case of an abuser, frequently, but let's say you've got a parent with dementia, well, the court's very loath, if that parent's being cared for by one child, the court is very loath to remove that parent. Why? Because it can be really hard for that family member with dementia to go to a new situation. So what you're likely to see is that same situation continue, except now that person, because we've integrated it into the settlement, that yes, you can continue to take care of mom, but you have to allow visitation, and these are the terms of the visitation. And really what it creates is a scenario for the fighting to continue. So instead of there being a resolution, now we want that person, more likely than not, you're going to see continued abuse. You're going to see that agreement violated, and you're going to go back to court and ask for contempt. The court, frustrated with the whole situation, is likely just to explain to everyone that and again, been there, done that, if the parties can't work it out, they're going to give mom's custody to the county, and that's it, because they don't want it coming back to their court. So
I guess one thing I would say is, if the parties are relatively reasonable people, you don't have a true bad actor, then maybe the mediation kind of thing works way better. But if you have a bad actor, or really a true bad actor, it's just one more tool for the bad actor to use to get independence.
Right. It can be very abusive if somebody walks into that mediation with the intent of not settling, with the intent of it's going to be my way or the highway. I'm never, again, based on my experience in this context, it's not true for other contexts, so I want to be very clear that I'm talking about a very limited scope here. But in these contexts, again, I find that it becomes another way for a family member to continue to drag around another family member and just kind of continue that abuse, emotional abuse. It can be very difficult for somebody who's got a dementia to see family members fighting this way, because they are invited into the process. Okay, so again, it can be a way for a family member to continue that abuse that's been going on, and to continue to afflict other family members with those bad feelings, with hurtfulness, with stubbornness, it essentially becomes Diane Weinberg's Christmas fund, because we're not coming to a resolution, but it's another way to cause a family member to incur a lot of expense, because we have to prepare for this process. We have to go in with good faith, and I will go in with good faith with an idea that I would like to settle this matter, but I'm just not optimistic that I'm either going to settle or that the settlement's going to stick.
So I would say, at the bottom line, I think...
Well, I've got one...
Okay, go ahead. Keep going.
One more point.
And also, this one's live. Go ahead.
Yes. There is one more point that I want to make, particularly in a probate court context, which is probate court is a court of limited jurisdiction. So maybe we have a whole bunch of issues. We've got a trust that we're trying to deal with. We've got a visitation issues we've got to deal with. We've got other care issues that need to be addressed for this family, working at a care plan for that disabled individual. Probate court can't enforce all the terms of the settlement. And so what happens is we have this comprehensive settlement, and the probate court may or may not incorporate parts of it and into its order. But typically what they'll do is the probate court will say, well, this is beyond, if it's a trust issue, it's beyond the scope's ability to enforce it. So we end up having to go to superior court and cost superior court if there's a contempt, if there's a violation of this contract, this settlement agreement between the two parties. So again, Diane Weinberg's Christmas fund looks better because now I've got to take my client to superior court to enforce this order, but it's not helpful to my client. My Christmas fund is fine. I would much rather have a more cost-effective solution for my clients. So that's again why I'm not as much of a fan of mediation and other alternative dispute resolution in this context. I just don't feel I don't feel in most cases that my client is going to benefit from it, that in fact it's going to be more expensive, it draws out the process, and really makes it more painful for everyone involved.
Right. So here would be my summary as an estate planner. Number one, avoid disputes. Set the plan up, put the right person in charge. If they're not if there ends up being a bad actor, we get them removed. So avoiding the dispute to start with, that's the number one thing to do. Number two, if you have a dispute and you may be forced to go into a mediation, but when you're considering whether you should settle or go in if you're not forced to do it, you need to think about, is the other side a true bad actor? And if it is this really worthwhile? We're just spinning our wheels and it's going to end up with more expenses. Or is this something we truly, with assistance of a mediator, collaborative third party, or some other assistance, we get someone pushing us together to come up with some set we can both live with? Or is that not the case? So it's avoid, figure out if we have a legitimate shot here to get an agreement that actually you can live with and that they will actually abide by it. If they don't, it may not be worthwhile other than being forced and you got to sit down and then leave. So that would be my take.
So thank you very much for your time. This is our November issue of the newsletter,
the Passion Estate Planner newsletter via video.
So thank you. Have a wonderful Thanksgiving, and we look forward to speaking with you after the holidays. And if you need to have any questions about today's presentation, please feel free to call our office at 678-720-0750 or contact Kim through admin@morgandesalvo.com. Thanks again. Have a great day.
Thank you.